Yes.
Good afternoon to all the board members.
Be seated, please.
Thank you, sir.
Chandani ji, you are singing, your hobby is singing bhajans and listening music.
Yes.
Which type bhajans you sing?
Sir, normally all the bhajans I sing, but since I belong to Jainism, so I sing Jain bhajans.
Can you sing 2 lines of any bhajan?
Yes, sir, sure. नवकार मंत्र मंत्र इस मंत्र की महिमा भारी है, आगम में कथी गुरु पर से सुनी, अनुभव में जैसे उतारी है.
Very good. Did you ever visited any court?
So recently, after giving my means examination, I went to the family court of Alwar, and there I saw the pleadings and even contested the case.
What is the sitting structure of the court? You see, judge sits in the middle side. Thereafter 2 seats are there. One on left side of the judge and another in the right side of the judge. What are the works of these 2 peoples who are sitting beside the judges?
Yes, sir.
What does they do?
So one is the readers out, and
क्या काम होता है उनका?
so basically what he does is he whatever the judgment is delivered by the honorable justice, so he just writes it down in a proper manner, whatever it is rendered to him, and thereby it is delivered to the parties out thereafter.
Who writes the judgments? Reader?
No, sir. The judgment is delivered by the honorable justice, and sorry, sir, I do not know who writes it.
What work is being assigned to these 2 people?
Sir, I think giving of the file to honorable justice, sir, is done by the one member sitting right to left or right to him, and the other one has this work of writing down, sir. I'm sorry, sir, not exactly.
What is the nomenclature of these 2 peoples?
So one, so far as I can recall, sir, one is readers out and the other, sorry, sir.
Did you ever heard about the name Jamadar?
Sorry, sir.
Not. Who is Tamil Kuninda?
Sir, Tamil word I can recall, but
Who is Tamil Kuninda?
sir, if you allow me, I can try it, sir, but I do not exactly know, sir.
Try.
So maybe the serving officer is called the Tamil Kuninda.
Yes. Did you go through the provision enshrined in section 10 of CPC?
Sorry, sir.
Section 10 of CPC.
Yes, sir.
What is the exception of section 10 CPC?
Sir, section 10 CPC is mainly res sub judice concept, but when it comes to the exception of section 10 CPC, it is any case that is pending in foreign court that will not be a bar to the Indian court to try the case.
Yes. Whether a magistrate or judge can ask any question irrelevant to any party present in the court?
So far as regards the section 149 of Indian Evidence Act, any improper or unlawful question should not be asked, and if it is so asked, then under 150 of Indian Evidence Act, the requisite proceedings can be taken against him.
No, I am asking irrelevant, not improper. Whether any question can be asked to any person, not party before the court, but present in the court. Whether any law empowers the magistrate or judge to ask any question to any person present in the court who is not party in any proceeding before the court. That question may be irrelevant. Can he ask?
So, if we go by the legal provisions, the irrelevant questions must not be asked.
Not irrelevant. Yes, irrelevant. Yes. Not be asked.
So they must not be asked, but there is a proviso to it that if it relates to the case, that for example, if he takes in cross-examination of the party or any other person who is present in the court, then in sir that case he may ask the question with the permission of the honorable court presiding officer of the court.
Now, Ms. Jain, let me know one thing.
So,
167.
A is beating B and committed grievous injury. C came to intervene. A again give beatings to C
yes,
and committed grievous injury. Police filed charge sheet under section 325 IPC,
yes, sir.
and you have convicted A for section 325 IPC. How will you sentence them?
So the imprisonment and fine given to A will be as per the liability he has of giving grievous hurt to B as well as C. So he will be punished for these two persons, victims. When we go by the provision of 325, the maximum punishment that can be provided to the accused is 7 years. So, adhering to the strict provisions of law and having regards to the facts and circumstances of the case, I will be giving him the punishment as the case suits, as per the demand of the case.
Only one punishment.
Sir, fine will also be awarded.
Fine.
Yes, sir.
What is the ceiling of fine for the magistrate first class? How much fine? How can maximum fine can be imposed by the magistrate first class?
Yes, sir. Sir, Judicial Magistrate First Class under Section 29 of the CRPC has the power to impose punishment as well as give a sentence of fine also. So, in that maximum 7 years of imprisonment can be given by CJM, and by Judicial Magistrate First Class it is maximum of 3 years imprisonment.
Maximum 3. If magistrates is of opinion that punishment should be more than 3 years, then what is the procedure?
Sir, under section 325 of the CRPC, when the magistrate cannot pass the sentence sufficiently severe, then he can commit the case to the honorable court that is empowered.
Which court?
Sir, suppose if we are talking, as you said, sir, the question is that a judicial magistrate second class cannot do. So he will commit the case to his seniors, that is judicial magistrate first class or CJM respectively.
Did you ever heard about the DALSA?
NALSA, sir.
DALSA.
Yes, sir.
What is it?
Sir, it is District Legal Services Authority, and Legal Services Authority Act of 1987 empowers them, and in the hierarchy there are certain other services also, that is National Legal Aid Services and State Legal Aid Services as well.
What is the name of District Judge Alwar?
Sorry, sir, presently I cannot recall.
Who is Collector Alwar?
Sorry, sir, this also I do not know.
You belong to Alwar?
Yes, sir. No, sir. I am resident of Jaipur itself,
Jaipur.
but I went to Alwar.
Your
For
documents are Alwar. Your address was sometime Alwar came. Okay. Who is District Judge Jaipur? How many principal district judges are there in Jaipur?
Sorry, sir. This also I don't have knowledge.
Who is Chief Justice of Rajasthan?
Sir, presently we have acting Chief Justice.
What's his name?
Sir, Honorable Justice Maninder Singh Ji. To complete
Manindra Mohan Srivastava.
Yes, MM Srivastava sir.
Who is Governor of Rajasthan?
Sir, Maniniya, sorry sir, I have just left it off my mind.
Who is Prime Minister of India?
Sir, Maniniya Pradhan Mantri Shri Narendra Ji Modi.
Who is Law Minister of Rajasthan?
Sorry, sir. Sir, if you permit me 5 seconds, I can recall.
Sure.
Yeah.
Sir, sorry, sir. I cannot.
Who is Law Minister of Central Government?
Sir, माननीय श्री किरण जी रिजिजू.
ये समन केसेस क्या होता है?
Sir,
समन केस.
so summon cases are those cases in which the maximum punishment that can be dealt under the case is 2 years. If less than 2 years imprisonment is there, then we can treat it as a summons case.
What is the difference between the procedure of summon case and warrant case?
So basically, if we go by the trial provisions, then there are certain differences. For example, under chapter 20 of CRPC comes the trial of summons cases, whereas in chapter 19 comes the trial of warrant cases. So second difference that I can figure out presently is warrant cases are instituted on police report and otherwise then on police report also, that is on the complaint, whereas no such classification is there in the summons cases. And so thirdly, if we go, when it comes to the charge, then only the substance of the charge is read over to the accused, whereas in the warrant cases, the framing of charges are done.
What is the difference between the police report, warrant case and complaint case में क्या अंतर है?
Yes, sir.
ट्रायल में क्या अंतर है?
Yes, sir. So first of all, the range itself is a difference. Chapter 19 has 2 ranges. It is segregated into 2 ranges. From 239 to 243 comes the warrant case instituted on police report, whereas from 244 to 247 comes the warrant case instituted otherwise than on police report. Secondly, sir, in a warrant case instituted on complaint, it is evidence of the prosecution is required initially, sir, without even framing the charges against the accused. Whereas the vice versa, when it comes to the police report, this is not the case. What happens is the first under 239 the discharge application is made out, and if the magistrate considers that prima facie case is not made out, then he will discharge the accused, or if so that he finds that there are prima facie cases against him, then he will frame the charge under 240, and then then the trial will proceed accordingly.
एक्सपर्ट ओपिनियन की क्या महत्व होता है?
Yes, sir. So, Section 45 of Indian Evidence Act contains the provisions relating to expert opinion. So, sir, expert as per Indian Evidence Act may be in the field of science or law or literature or fingerprint or handwriting, thumb impressions. Sir, whenever the expert's opinion is taken by the court in the relevant cases, then even under 293 CRPC we relate the provision. When we link it with other provisions also, we have 293 CRPC where government scientific experts are also taken. We have a certain list of persons who are contained in this list. So sir, in that case their relevancy is taken by the honorary.
क्या कोर्ट ओपिनियन के विरुद्ध जा सकती है? एक्सपर्ट ओपिनियन के खिलाफ भी जा सकती है कोर्ट?
Yes, sir, definitely the court can go irrespective of what the expert opinion is. The reason is that, sir, so being a scientific evidence, we cannot 100% rely on it. Since science is what? Science is either a human or a machine. So machine can do errors and definitely human can also commit mistakes. So the court has to apply its judicial mind and thereafter to see whether the scientific evidences on the record are relevant or they are to be considered or not.
टेम्परेरी इंजेक्शन किस में देते? टेम्परेरी इंजेक्शन इन विच सेक्शन?
Yes, sir. Sir, CPC Order 39 reads about temporary injunctions and interlocutory orders, but when we divide it from Rule 1 to 5, we have temporary injunctions. So, sir, Rule 1 has 3 basic principles giving in what cases the temporary injunctions may be granted or whether it has to be refused by the court.
What are the grounds for granting temporary injunction?
Yes, sir. So, 3 fundamental principles are to be considered prima facie. First one is balance of convenience, and second is irreparable loss, And third, I'm sorry sir, the third one should have come first, that is prima facie case.
What do you mean by private case?
So prima facie case means by just looking over the case prospectus or the case circumstances, we get to know whether it is to be apt case to be given the temporary injunction or not.
Sir,
Chandani, while going through your biodata, I saw that you were a science student in the graduation,
Yes.
and then you shifted to law.
Yes.
What was the reason? I mean, what motivated you to move from science to law?
Yes, sir. So very honest reason that I would give is, in my school days, there were only 3 streams available. One was humanities, other was commerce, and one was science. So sir, I could not opt for commerce as my interest was least in that. And secondly, I had the 2 options, humanities and science. So having regard to the demand of the present state of our society, that science being a wide scope to ample opportunities are there in the science stream to explore yourself and to have an interest thereon. So sir, I pursued my BSc in the science streams, and later when I got the right directions from my seniors that you should go for LLB. So sir, I went forward and opted for LLB as my career.
Who were those seniors?
Yes, sir.
It was from the family or some outside?
So my family members themselves were there. So my elder brother is there in the Rajasthan High Court. So he guided me to opt for law.
Okay, again while going through your biodata, I saw that in the first attempt in the constitutional law there is a doubt, and then second you cleared it. What was the reason?
No, sir, this is my very first attempt, sir.
No, not for the RJS, for the law, graduation law.
Okay, sir.
Getting my point?
Yes, sir, I got your point.
In your mark sheet.
Yes.
uh,
Sir, the reason
What
was.
was-
Yes, sir.
Because all other subjects are clear.
Yes, sir.
Only constitutional law there is a doubt. And then in the second attempt, I mean next examination you cleared it.
Yes.
What was the reason?
Sir, the reason was that somebody at the back of me was having an unfair means check. So I was caught irrespective of the fact that he is the real one who has brought the check. So I was taken to the disciplinary committee, and after 2 months of the final result by them, I was clean sheet by them, and thereon I was allowed to give my exams in the next attempt that was available.
Okay, now that tell me what is the constitution?
So constitution is a document, if I say, a document which has the rights to the we the people of India. The very first line of the preamble is the summarization of the constitution that we the people of India give to ourselves and enact this law. So constitution is what, sir? It is a document that gives the rights as well as contains certain liabilities for the Indian citizens and for other people also who are not Indian citizens.
Is it only this or something else also there?
Sir, lot is there. It is a elaborative document that was the fundamental to the governance of our country. And if in one line I had to summarize this constitutional law, then I would say, sir, this is something that aspires the lot of strive and excellence towards what we can aspire for in our futures.
Which part of the constitution you considered most important?
Sir, sorry sir, if I had to name one article or a chapter.
It is up to you.
Okay, sir. Sir, I would say Article 32 is, I think, for me the most important of all, so far as I can, as my opinion is concerned.
Why only Article 32?
Sir, definitely, sir, there are certain other provisions also which are equally important. If I had to pick one of them, sir, then it would be Article 32. The
Yeah.
reason is,
How do you weight then Article 32 and Article 226? I mean, which one is heavy and which one is lighter in your opinion?
yes, sir. Sir, Article 226 is the writ jurisdiction of the High Court, whereas Article 32 is the Supreme Court's writ jurisdiction. Sir, when we come to the ambit of which one is greater, then definitely, sir, Article 226 has the wider ambit than Article 32. And sir, if I had to give the reason also, then the reason will be, sir, in Article 32, the writs can be enforced only for the enforcement of fundamental rights, whereas for other matters, Article 226 has the area.
You have visited family court Alwar. Whether a divorce petition filed under section 13, 13 by way of
Sorry, sir. I do not know the section 13 of Hindu Marriage Act. The reason being, sir, it was not in my syllabus. So, sir, due to a restrictive time in judiciary, I could not give time to other subjects.
in subject your syllabus, labor law was there.
No, sir. Labor law was. It was in my final year of
Yeah.
LLB, sir.
What is subject?
Yes, sir. I had this.
What is meaning of industry?
Sorry, sir. I do not know, sir. The
Basic fundamental industry disputes act.
Yes, sir.
Industry.
Sir, if I had to give a general definition of the term.
Definition you did.
Sure, sir. Sir, the general definition of the term industry can be industry is a establishment where the labor is taken and the output is given in terms of machineries and human resources.
Other things are there to be considered. Who can be said to be a workman?
Yes, sir. So, workman force is the people who give their labor to the industry.
Slightly give in the legal sense.
Legal sense definition of workman.
Yes.
Sorry,
And
Legal
sir.
definition of
relating
industry.
to the laws, different laws, labor laws.
Sorry, sir, as this was not in my subject, so sir, I could not have been.
You have secured good marks in the labor law.
Yes, sir. It's been almost an year, sir. So it's presently for me difficult to revise and just relate this to a very legal language.
Suppose two remedies are available one under general law, under a special law.
Yes, sir.
Whether a chooser can go in both the or in one or can only opt to one.
Yes, sir. Sir, so far as I have learned and understood the law, special law always prevails over the general law. So if there is a provision contained in the special law, then we have to go by that only, and it will be supreme irrespective of what is contained in general law, because special law
If
prevails.
the remedy is also available under the general law, irrespective of that law,
Yes.
then whether he can choose the remedy under the general law or is prohibited.
Sir, I do not know exactly what the law says, but sir, I can try.
A
at
remedy
least.
like you says a particular act, remedy is there. In general law, the remedy is also there. Whether the person can choose only the remedy at a particular act is barred under to get the remedy in general law.
Sir, if it comes to exhaustion,
Both the in general law and the special law, whether he can avail the remedy under the general law or not.
sir, he can avail the remedy under general law, I think.
Can or either choose, is his choice.
Sorry, sir. I can.
Mandatory. The choice is there, or whether it's mandatory to choose the same.
No, sir. Definitely, it's the choice of the party to exhaust the remedy wherever he wants.
What is basic difference under Order 7 Rule 10 and 7 Rule 11 CPC?
Sir, if we have to find out the basic difference between Order 7, Rule 10 as well as Rule 11, then first one is under Rule 10, return of the plaint is considered, whereas in Rule 11, rejection of plaint is considered.
So, what is the remedy available if the plaint has been rejected under Order 7 Rule 10?
Yes, sir. Sir, it has been given under Rule 12 that the rejection of plaint shall not be a ground to bar the person, the petitioner, from filing a fresh suit. So he can go for filing a fresh suit.
And suppose under order has been passed under 7 rule, under order 7 rule 11, then what remedy has got?
Sorry sir, if you can repeat
If
the
the
question.
order has been passed under order 7 rule 11 by the court, then the what remedy lies with the plaintiff against that order?
Sir,
If the plaintiff is rejected, what is the further remedy for the plaintiff?
Sir, as I pointed out that sir, if the plaint has been rejected, then he can go for filing a fresh suit. He can go for filing a fresh
If
suit.
the plaintiff is not agree with the order, then what should he do? What is the remedy for him?
Sir, he can go for revision under 115 CPC, sir.
That is the-
115.
No, no. After amendment in the CPC,
Yes, sir.
can't avail.
There are two orders. One, if plaintiff is rejected while exercising power enshrined in order 7 rule 11 CPC. And if the application is rejected, what are the remedies in both cases? जब प्लेंट रिजेक्ट हो गया है,
तो क्या करें?
एप्लीकेशन मंजूर हो गई है,
Yes.
तब तो क्या रेमेडी है?
Yes.
और एप्लीकेशन रिजेक्ट हो गई है, तब क्या रेमेडी है?
सर, अगर प्लेंट रिजेक्ट हो गया उसका, तो ही कैन गो फॉर फाइलिंग द फ्रेश सूट. बट इफ द
फ्रेश सूट नहीं, उस ऑर्डर को अगर वो चैलेंज करना चाहे तो उसके लिए क्या
Okay.
रेमेडी है?
Yes, sir. Sorry, sir. Now I can relate to the question more comfortably. If that has been rejected, then he can go for setting aside that order.
What is remedy for that? For setting aside that order?
Sir, he can go for appeal, sir. He can go for appeal.
एप्लीकेशन रिजेक्ट होने पर अपील होगी या एप्लीकेशन अलाउ होने पर अपील होगी?
Sir, under order 43 rule 1 it is given that what all sort of orders are appealable orders. So that order refusing the plaint will be appealable order, but the granting of it will not be an appealable case.
Yes. CRPC proviso section 173. What does it say?
So CRPC 173
Yeah.
talks about police challan or the final report by the police, that is called the charge sheet.
Charge sheet may be in positive form or in negative form,
Yes.
or whether the magistrate is bound by the charge sheet submitted by the police,
So the
whether he can direct for investigation, further investigation,
yes.
what powers he has got.
Yes, sir.
बेसिक फंडामेंटल है. चालान पेश हुआ पुलिस, क्या मजिस्ट्रेट उससे पाबंद है पुलिस रिपोर्ट से? नंबर 1. व्हाट ही कैन डू, व्हाट पावर्स ही हैज गॉट.
Sir, the first answer would be that the magistrate is not bound by the police report filed by the police, and he can proceed further, giving the directions of further investigation also to the police to investigate the case. If he
Has
is
the
not,
magistrate got power to direct reinvestigation?
no sir. Sir, he doesn't has the power to order or direct for reinvestigation, but he can direct for further investigation.
Which is you know the leading case regarding this, the powers of the magistrate,
Yes, sir. I know, sir.
name, title.
Sir, Veenubhai Haribhai Malviya versus State of Gujarat is a leading case, and one more I can recall, sir. Irshad Ali case is also there.
Sadali Gujarat case.
Yes.
What is the language of the court?
Sir, section 272 of CRPC contains the provisions relating to language of the court, and apart from the High Court, sir, the language of the court shall be like designed by the state government. State government is basically the authority to design it, and when it comes to having the language of the court, it is English.
In Rajasthan, what is the language of the trial courts?
Sir, it is Hindi.